The court said, "Please get the jurors."
The law clerk said, "Jury entering."
Jury present.
The court said, "Please be seated." Members of the jury, we will now hear the government's rebuttal by Assistant United States Attorney Juliana Murray.
Ms. Murray said, "Ladies and gentlemen, you've heard this before, and it's true. The government is the only party with the burden in this case. We have to prove the charges beyond a reasonable doubt. Now that's the very same burden of proof that is applied in criminal cases every single day in every single courtroom in this country. We've embraced that burden, and we've met that burden. But when the defense chooses to make arguments, it's your duty to scrutinize them, to examine whether they line up with the evidence, with the testimony that you've heard during this trial. And they don't. Now, each fraud scheme that is charged proves MilesGuo's intent as to the next fraud scheme. And collectively, they prove that MilesGuo is guilty of the conspiracy charges in counts 1 through 4. The questions on counts 1 through 4, the conspiracy charges, are merely whether Guo had an agreement with anyone to commit certain crimes: wire fraud, bank fraud, money laundering, securities fraud, and racketeering. That's just whether he agreed to do that. And of course, he at least agreed to commit those crimes. You can judge this based on his actions and the actions of his co-conspirators alone. Now, counts 5 through 12. Those are the substantive counts. They ask you to look at whether Guo committed or aided and abetted the private placement, the farm loan program, G clubs, and the Himalaya exchange. Then whether Guo used or aided and abetted the use of $100 million worth of fraud money to invest in Haman. And you've seen the evidence. You know that he did all of those things. You know that he is guilty of all of those crimes. Now I'm not going to address all of the arguments that Mr. Kumraju made, because frankly I don't need to. Mr. Kumraju spoke with you a lot yesterday about connecting the dots in this case. The dots are all of the evidence that you've seen and heard during this trial. They include the witness testimony, the emails, and loan agreements and bank records and other documents, and the dozens of defendants' video broadcasts. And a lot of the defense argument were distractions. Efforts to make you forget about the crushing evidence of MilesGuo's guilt. To make you forget about the dozens of entities that made up MilesGuo's enterprise. To forget about the complicated web of hundreds of bank accounts in the US, and in places like the BVI, the UK, Switzerland, Abu Dhabi, and Kyrgyzstan. To forget about the large money transfers, sometimes 2 or 3 different bank accounts in a single day, that were done to conceal the true source and purpose of Guo's fraud proceeds. To forget about the sham loan agreement, the consulting agreements, and the other documents that were created simply to paper those transactions to make them appear to be legitimate. To forget about the hours and hours of video of Guo broadcasting to his followers, promoting himself and his enterprise, telling his followers how he would make them rich, how they could never lose money with him, how he guaranteed it. Forget about the victims that you heard about. These are people who were followers of MilesGuo. They watched those videos. They invested their hard-earned money in his investment opportunities. Why? Because they trusted him. They want you to forget how this man, MilesGuo, the man that they believed in, robbed them. They want you to forget the evidence because it proves that MilesGuo is guilty. Now, the defense spent much of its energy during this trial focused on Guo's political activism. Is MilesGuo a real political activist or not? I don't know. I don't care, and neither should you. Because that's not what this trial is about. MilesGuo's true stance on the CCP. It's not a question that's being asked of you in this case. The question is whether he intended to commit fraud. And he did. In a valiant effort to confuse the issues before you, Mr. Kumraju then said, "There's no evidence that MilesGuo ever took a penny to attempt to undermine the political movement. So the government hasn't met its burden." He argued that Guo would never intentionally harm the movement. The movement that he built by stealing money from supporters. And Mr. Kumraju said, he can't have had the required criminal intent. Now, it's true. You cannot take the whistleblower movement and the NFSC out of this case about Guo's criminal fraud enterprise. They have featured prominently in the evidence that you've seen and heard. And you know now that you've seen all the evidence that that is by design, Guo's design. Because that's how Guo's criminal enterprise worked. All of these investment opportunities. They were offered to members of the whistleblower movement and the NFSC, Guo's followers. Why? Because Guo preyed on a community of individuals who shared in the anti-CCP view. They were, as Mr. Kumraju himself stated yesterday, Guo's target audience. Did Guo's marketing to this group necessarily exclude a broader set of potential investors? Of course. But that wasn't bad business sense. That was Guo's plan. He preyed on the pliable followers who believed the messages he espoused in his hours of broadcast. People who would be willing to volunteer their time, transcribing and translating his videos. At the expense of their personal lives. All while collecting whatever money he could from them because they believed that he would take care of them. They believed they would get huge returns on their investments, and they believed that if they suffered losses, he would repay them. They believed that because that's what he told them time and time again. And when people complained that they were not getting what they were promised, stocks, profits, benefits, cryptocurrency, MilesGuo turned against them. He branded them CCP spies. And he outed them to the sprawling and fiercely loyal whistleblower movement. The defense wants you to believe that Guo could never possibly have the criminal intent to take money from his followers by lying. The defense is correct about one thing: Guo loved the movement. And at least one of the reasons that he loved it was because it was his personal piggy bank. Now I'm going to walk you through just a few of the defense distractions that you heard yesterday and today. You heard some arguments yesterday from Mr. Kumraju about the GTV private placement. I'm not going to talk to you about pizza and soda like Mr. Kumraju did. I'm going to talk about the evidence. First, defense counsel argued that Guo did not commit fraud because he did not lie about what the GTV private placement money would be used for. That's incorrect. Guo said in the April 20, 2020 launch video that the money would be used for GTV. He did not say it would be invested in a hedge fund. So that was a lie. But in any event, Mr. Kumraju completely ignored what Guo said to the old chairs like Wei Chin, who you heard testimony from during this trial. He told them that there was no risk to GTV. That the investment money was guaranteed. Defense counsel completely left out that Guo made this very same promise again on June 2, 2020. The day that the private placement closed, and that was recorded. That's in Government Exhibit Z9 on page 8. It's up on your screens here, June 2, 2020 in Guo's broadcast. In this GTV investment, I had a separate conversation with each investor. This is a serious and solemn commitment and responsibility of Wengue Guo to you to be responsible for this investment forever. This is a legally valid commitment, an attitude. He's acknowledging what he told the old chairs. That there was no risk in the investment. None. That he would be responsible. Was he responsible? No. GTV and Soraka lost investors' money they still haven't paid back till this day, more than $30 million. So, yes, Guo lied. He lied about what the money was for, and he lied that the investment was guaranteed. He said there was no risk. Next, counsel argued that in any event it was fine for Guo to invest in the Heyman Fund because that $100 million. That was Soraka's money. It wasn't investor money. First of all, that's factually inaccurate. The Soraka investment came from the JP Morgan 5601 account. That's where the investor money for the GTV private placement was sent. That's the source of the Heyman investment. It's not Soraka's money. It's supporters' money. It's victim money. And even MilesGuo acknowledged this. Again. Government Exhibit Z9, page 6, Guo boasted about the success of the private placement. He said they had an initial valuation of $200 million. But instead it exceeded the highest expectation and raised $350 million, $350 million received. Which is just for the contracts with GTV. That means that the entire $350 million that was raised through the GTV private placement. It was all for investment into GTV. There wasn't some special secret overflow of $150 million that magically belonged to Soraka and not GTV. And Soraka wasn't able to use a portion of the GTV money however it wanted because the investors who sent that $350 million, they all sent it to get the GTV stocks that Guo promised them. So next defense counsel says, well, the investment in Heyman was totally fine because MilesGuo thinks that's how to take down the CCP. What? Does that make any sense to you? A $100 million investment in a Texas hedge fund can destroy a global superpower that has an economy in the trillions of dollars? Does the hedge fund have anything remotely to do with taking down the CCP? Of course not. You heard from Ms. Schottenheimer. It's an extremely high-risk bet on what might happen and what never happened with the Hong Kong dollar pay. And Guo's statements to Kyle Bass in the 2018 interview, they don't say anything different. Guo did not say and Bass didn't say either, hey, we both hate the CCP, one way to take them down. Invest in my hedge fund. They never say that because it's nonsense. And by the way, there's no way that Guo thought investing in the Heyman fund was a way to take down the CCP. Do you want to know why? Because if he thought it was, he would have bragged about it on his broadcasts. He would have told his fellow freedom fighters, great news, we invested your money in the Heyman fund. It's a bet that will take down the CCP. That's not what he says at all. Look at what he did say. He covered it up. He told the fighters that nothing bad happened. He didn't mention anything about trying to fight the CCP with the Heyman bet because he wasn't. You know exactly what he was doing with that $100 million investment. He was trying to make money for himself and his family. Third, defense counsel argues that if the Heyman investment was hidden, they wouldn't have been so brazen about it. But they did hide it. They did the internal transfer from the 5601 account to the 2038 account. They did that for the purpose of concealing that the source of the funds in the original account was GTV investors. There's no reason to do that internal transfer other than to hide the funds. And William J.E. asked Steele Schottenheimer, hey, can we send the money from a different company? When she said no you can't. What did they do? They opened that second account. The account that was used for the express purpose of that internal transfer. The account that was used to clean the money before it was sent on to Heyman. And Mr. Kumraju mentioned yesterday the document that was submitted to Heyman in connection with the investment. And he said, well, they disclosed on that document that the source of the money, the $100 million, was the sale of the shares of the subsidiary. What Mr. Kumraju didn't show you was other evidence in this case. This was the original investor profile that was submitted with the Heyman investment. There is no description of source of wealth here. It's only when they go back with their new clean bank account that they provide this explanation. The explanation that you saw on the right here, selling shares of subsidiary. And by the way, there's nothing unusual or strange about William J.E. being the primary contact for Heyman. Mr. Kumraju mentioned that yesterday. He said it wasn't MilesGuo. It was the moneyman William J.E. That's how Guo works. You know that. He used agents. He had other people deal with paperwork for him. That's to be expected. And Steele Schottenheimer told you, this is often how it works with wealthy family offices. Let's talk about the movement again. The companies that Guo used to collect money from his victims, they're just that. Companies, businesses, entities with supposed commercial purposes. Like the G Club membership company and the Himalaya cryptocurrency platform. And when it benefited him, Guo himself put distance between those entities and the movement. We talked about this a bit yesterday. This is June 28, 2020. A broadcast. He says, the NFSC, Please remember in the future. It's a quasi-political entity. That's the entity affiliated with the movement. Then he says that G-Series, GTV, G-Fashion G-Clubs, G-Coin and G-Dollar have no substantial connection with the NFSC. It's like an NGO. But the G-Series are completely commercial institutions, including the Himalaya farms. In that same broadcast he says, to the brothers in arms who wanted to donate to the Himalaya farm, let me say this once again. Any Himalaya farm that accepted donations will all be disqualified. You can invest, but you cannot donate. Our whistleblower movement does not tolerate the asking for money. Later he says, this is completely a business operation. Do not link the G-Series under any circumstances, to the NFSC. That is all bullshit. Those are MilesGuo's words distancing the political movement from the businesses. And by the way, all of Guo's schemes, the six that AUSA Finkel went through yesterday, the rule of law, GTV, the farm loan program, G-Club, the Himalaya exchange and A10, those 6 schemes. As well as the others that you heard about, H-Coin lockup, G-Bank, G-Dollar, they tell you something. Something important about Guo's modus operandi. This is what he does. He was not paid by any of these businesses. By these companies, and they were businesses. They were not political organizations. So if he's not being paid, why is he doing this? It's for the fraud money. He doesn't have a job. He doesn't clock in and clock out somewhere every day. He spends his days making broadcasts that pitch these business opportunities. All similar opportunities with grand promises of high returns, stock, and the assurance of getting rich quick. He repeats those promises over and over again. He promises to guarantee the investments. And you know those are all lies. Now yesterday Mr. Kumraju told you that MilesGuo didn't commit fraud by promising stocks for G-Club because G-Club didn't give stock until sometime in the future. It was a generalized promise. So Mr. Kumraju said investors could not reasonably expected stock in exchange for their G-Club membership payments. You know what MilesGuo said. You know how he raised money through G-Club. August 7, 2020, he says, in the past I said, if you buy G-Club, you will have G-Fashion stocks. It's not the first time that he said that. He repeated that over and over again. He promised stock in exchange for G-Club membership payment. And you heard that from the victims who bought G-Club membership. They expected stock. That's what they were promised. Now in the same broadcast as he often does, he tries to walk it back. He says, we shouldn't even be talking about stocks. It's a problem if we use that word, stock. And you know why that is. It's on the do not say list. The list of things that MilesGuo is not supposed to say in his broadcast because they can get him into trouble. Because those are the things that he says when he lies to steal people's money. But he slips up sometimes. And that's exactly what he's done with G-Club. He told everyone that they could get stock. And that's what they expected. By the way, despite what the defense wants you to believe and what they mentioned today a number of times, the G-Club fraud. It's not MAWA. It's not the Lamborghini that was in MilesGuo's garage in Connecticut. The G-Club fraud, plain and simple, is Guo's repeated promise that members would get stock that never existed. And he brought in hundreds of millions of dollars through G-Clubs based on those lies about stock. That is the G-Club scheme. That is the crime. So next, the farm loan programs. The farm loans were designed to paper the stock investments after the SEC started investigating GTV. Mr. Kumraju pulled up a loan agreement. And he talked you through a couple of the different terms that were on that document. He said there's a 3-year period. Those loans haven't matured. The government was premature in bringing this case. They can't possibly say that the loan program was a fraud if the money wasn't repaid. Ladies and gentlemen, you heard from victims. You heard from MilesGuo. You heard from Jenny Lee. The 3-year period of that loan agreement, that's another distraction by the defense. And you know that because before the loan term had elapsed, those victims were sent extensions. Extensions they never asked for, extensions they never wanted to agree to. Those loans were extended against their wishes, and I do want to note one feature of the farm loan program extensions. Those were extensions entirely at the discretion of the borrower. Just think about that for a second. You borrow money. The person who lent it to you is owed it an interest to a certain point. And you have an agreement that says, actually, I can keep it as long as I want. You're not entitled to anything. That's not how a legitimate loan transaction works. And those contracts, those loan agreements, they don't say stock anywhere on them. Even though you know from Guo's broadcast from the victims and from the other evidence in this case that that's exactly what the farm loan program promised. Now why don't they say that? Because Guo and the farms were papering the transactions to hide them from the SEC. Guo knew that these stock promises were wrong from the start. The farm loan program was a fraud as soon as Guo lied on his broadcasts about these loans. That's not a rush to judgment as Mr. Kumraju mentioned yesterday. That's an analysis of the facts of the evidence. Who knows, though, maybe it was a typo just like he said about the Bugatti contract. Now, the defense is tried to underline the government's timeline of events, which outline Guo's motive for setting up his fraudulent enterprise and executing his fraud scheme. This is yet another distraction from the defense, and you should reject it. First, motive is not an element the government needs to prove. You do not have to find any motive to find Guo guilty of any of the charges against him. But there is motive here. Guo's motive is money. He wanted money. Guo is rich. And you may recall yesterday when the defense argued that Guo's lavish lifestyle was before and after the fraudulent enterprise began. And Mr. Kumraju predicted yesterday that I would stand up here today and I would say, of course he was maintaining his lifestyle even after the Hong Kong seizure. That's because he was stealing money from investors. Yes. That's exactly what I'm saying. Because that's what the evidence shows. Guo himself told his followers that he was rich as a way to assure them that he was not misusing their money. He broadcast from places of wealth, his penthouse apartment, his yacht. He was surrounded by things that were expensive. He wanted them to know that they could have the life that he had. Now during his summation Mr. Kumraju repeatedly implied that the government had harped on Guo's wealth during this trial. Had argued that Guo was hurting for money. And he then claimed that the government has failed to prove evidence of Guo's supposed poverty. Again. Another distraction, and one that mischaracterizes the government's position and the evidence. But, yes. The Hong Kong seizure of Guo's billions of dollars just a month before he launched the rule of law organizations where he lied to his followers to get them to donate money. That's a fact and evidence that Guo announced the farm loan program right after the SEC started investigating the GTV private placement. That's a fact. That Guo launched the Himalaya exchange weeks after the SEC reached a $500 million plus settlement with Soraka. GTV and Voice of Guo. That's a fact. That Guo filed for bankruptcy just 6 days after the PX litigation contempt order was entered. That's a fact. And that Guo launched the A15 and A10 investment offering in the wake of the government's seizure of more than $600 million of the money he had raised through his fraud enterprise. That's a fact. You have all of the evidence. You can draw your own conclusion. But don't let the defense distract you with arguments about Guo's wealth. It is not a crime to be rich. But it's certainly not a defense to the fraud crimes that MilesGuo committed. Your common sense alone tells you that the suggestion that rich people would never defraud anyone for more money. That's ridiculous. So let's talk briefly about the Himalaya exchange which Mr. Kumraju brought up today. He said that the Himalaya exchange was intended to help people move their money more easily. Well, that's true. But one problem. The movement was one way. It was into the exchange and rarely out. It was difficult for anyone to get money out of the exchange, nearly impossible. Now, Mr. Kumraju showed you a couple of summaries of a few redemptions that happened through the exchange. He said, look. This proves that the exchange was working. Just think about what the exchange was supposed to be. MilesGuo promoted it as a cryptocurrency platform. He said you can use this to buy things. You can use your HPay app to buy things. You can freely exchange money with other people. What have you learned about the Himalaya exchange during this trial? It was a glorified Excel spreadsheet. There was no blockchain. There was barely an internal ledger. They maintained numbers of the money that came in on a file. And they could change the price that was displayed on the website on that file. All to make it seem like a legitimate platform to encourage people to send money to it. What else did you learn from the victims who testified in this case? Some of them who had Himalaya exchange accounts never had access even to those accounts. They sent money to the Himalaya exchange they couldn't even verify was there. Money that they were never able to take out. Money that MilesGuo held hostage when they wanted to get refunds of their other investments in his schemes. Money that Guo stole from them in order for them to get a return on their G Club funds. Mr. Kumraju also mentioned today that there's no evidence that MilesGuo has any connection to the Himalaya exchange. I'm not going to spend much time on that because that's absurd. Look at his own statements, Z9. That's the summary of MilesGuo's statement. You should look at that for all of the schemes. But remember what we said, in Z9 MilesGuo said in a broadcast, Brother 7 designed H-Coin. Brother 7. MilesGuo. He himself said that he was responsible for the Himalaya exchange. And just today, as Mr. Kumraju mentioned, MilesGuo sent Lian Li to go to the Himalaya exchange. He sent her there to audit the books and records to look at the finances of the exchange. Why would somebody with no connection have an interest in going and seeing what's going on with the money? He wanted to know what was happening because it was his exchange. He needed somebody to go and find out where his money was. And you heard a lot during this trail about the promises of gold, 20% backed by gold, a stable coin. Enough money one-to-one so that there's never any risk of losing your investment. Now Mr. Kumraju said this no gold thing is confusing. It's not confusing. It's criminal. So what distraction did we have today? Well, he brought up one bank record with 2 transfers to a company called Sharps Pixley. And from that Mr. Kumraju said Sharps Pixley is a gold company. They bought gold. They were trying to set up a system of having gold backed for the Himalaya exchange. Ladies and gentlemen, that's the theme you've been hearing consistently throughout this trial for each of the schemes. They were working on it. They were trying to put it in place. They were trying to get G Club member benefits. They really wanted to get the cryptocurrency up and running. They were working on the blockchain. They were going to buy gold. It's simply a distraction. It's not true, and you know that. Now, briefly, the Himalaya exchange redemption that we looked at that was on the summary chart from the defense summary witness. First of all, to describe those as redemptions, that's the defense's term. That's what was in the wire transfer information, but we don't know how that got there. The white papers don't define redemptions in connection with H-Coin or HDO. Those are simply withdrawals from the accounts. And, in any event, you know why there were limited withdrawals from those accounts. It's the same reason that there were limited refunds given to G Club members. Because eventually when someone complained enough, they decided, let's give some of the money back so that nobody realizes this entire thing is a house of cards. Let's just let a little bit slip out so it looks legitimate so we can keep going. Now we talked a bit today about the bank records. Mr. Kumraju had brought up one of our summary charts yesterday and again today. He said, look at these. These money movements, this doesn't show anything. You can't prove that every single dollar that came in through the farms went to this yacht or to this aircraft. The government does not have to prove at all that MilesGuo used the fraud proceeds. All we have to prove is that he conspired to get the fraud proceeds, but he did use them. He used them for luxury car expenses and yacht expenses. He used them to send $20 million to a Swiss bank account held by his son MilesGuo. And you know that MilesGuo then took that $20 million. And that's some of the money that he funneled back to the family office businesses. Those are the bank accounts that funded MilesGuo's lifestyle. You've seen the evidence. You've seen the money movements. This is a blatant attempt to distract you from the extensive web of money laundering. It's not a coincidence that money went from the farm loan program into William J.'s slush fund at the ACA Capital account in Abu Dhabi. And it's not a coincidence that money then went from ACA Capital back to the Guo family offices. Now today Mr. Kumraju brought up the defense summary chart. This is a summary chart that related to the GTV investment. And he said the government has all of these scary summary charts of all the money. They're just inundating you with all of these charts showing money bouncing around from place to place. He said that half a dozen times. Do you know why those charts scare MilesGuo? Because they entirely unmask his sophisticated criminal enterprise. Let's focus on the GTV summary chart that Mr. Kumraju showed you. He said to you that Ms. Espinosa's testimony was that Mr. Skirik's hand-drawn chart was fair and accurate. Fairly and accurately showed the transaction into the Hayman Fund. That is not correct. That is not what Ms. Espinosa testified to. She said that it omitted transactions. It did not accurately describe money movements. And you know exactly what it omitted. It omitted the internal transfer, the cleansing transfer, the clear evidence of money laundering.
Continued on next page.
Ms. Murray said, as I mentioned, the G Club's fraud, that fraud is the offer of stock in exchange for money. It's the lie the people who send money to G Clubs will get stock. That's the G Club's fraud. But we spent so much time on it, let's talk about the Malwa residence. The $24.5 million Darlington estate that Guo bought with G Club's money and then renovated for himself and his family. The defense cannot deny that the Malwa residence was bought with G Club's money. You saw the flow of funds. Tracing the money from Crane to Aaron Mitchell's law firm escrow account to the payments for the mansion. So because they can't deny the source of the money that was used to buy Malwa, they made various conflicting claims about the intended purpose of Malwa. They claim it wasn't another Guo family home. He already has a $70 million penthouse and an estate in Greenwich. Why would he need a third house? And in New Jersey? No. They say it was a base for the NFSC. Or wait. Was it a clubhouse for G Clubs? Today, it was an investment for Hamilton. It's really hard to know which story they want you to believe. But what you do know is they don't want you to believe the truth. It was Guo's home. He and his wife toured it with Christine Frosini. He bought it, setting up Scott Barnett, his head of security, as the unwitting owner on paper, the manager of the tourist fund entity that legally purchased it. Then Guo's lawyer, Aaron Mitchell, hired Amy Buck to manage payments of the more than $14 million in renovations and furnishings. All paid for with more G Club fraud proceeds, all hand-selected by MilesGuo. Just remember the evidence that you saw, including the videos of MilesGuo from his own phone, where he personally directed the renovations to the mansion. He was circling the floor plans for his wing, his wife's wing, his daughter's wing, and his son's wing. He was explaining in detail how closets should be combined, how rooms should be arranged. And you didn't just see and hear the defendant directing these changes, you also saw bill after bill. Document after document, referencing May's bedroom, that's May Guo, his daughter. Referencing the madam's closet, that's his wife. Scott Barnett told you the mansion was a mess during the extensive renovations. But he also said, and this is directly contradicting what the defense wanted you to believe today. He said that MilesGuo still went there a few times a week. He said MilesGuo would sleep in his bedroom, in his wing of his mansion for up to 4 to 5 night stretches in a row. And remember what AUSA Finkel showed you yesterday. His personal things were at the mansion. His medicine, his identification cards. This was one of his homes. The defense also said, well, it's not a big deal that Ms. Reyes, the CEO of G Clubs, didn't know about MAWA. There was a reason for that. That wasn't her role. That was Hamilton's investment. You heard from Ms. Reyes that she was aware of the other assets that were purchased with G Club's money. Now, those, like MAWA, were not actually for G Club's members. They were for MilesGuo. But this, the MAWA mansion. The $40 million collective investment of G Club's member funds that MilesGuo stole for his own purpose. She was never read into that one. Even setting all of those points aside. Even if Guo had bought MAWA as a G Club clubhouse. He never disclosed that G Club investor money would be used to buy it. He said that individuals who paid for G Club's memberships would get stock in GTV or in G Fashion or in G Club. He did not say they would get partial ownership in a mansion or use of a clubhouse. His lies about MAWA are a crime. Mr. Kumraju also pointed you to certain disclaimers for the various businesses that MilesGuo promoted investments in. He said that the victims should have considered the full mix of information behind these investments. They should have read the fine print. That's an improper argument and it provides no defense to MilesGuo. For what he did. I want you to remember Judge Torres's instruction on this point. The instruction was, in determining whether a scheme to defraud existed. It is irrelevant whether a victim might have discovered the fraud if he, she, or it had looked more closely or probed more extensively. A victim's negligence or gullibility in failing to discover a fraudulent scheme is not a defense to wire fraud. Yet another distraction that you can set aside. The defense consistently has claimed, as they did today, that all of these investments were intended to further the movement. To further the political agenda. Let's talk about the protests for a second. Think about who was protested. Think about where the protests took place. They didn't take place at the Chinese embassy. These aren't protests that are targeting the Communist Party. No. The protests took place at the SEC. They took place at the bankruptcy trustee's home, his office, and the homes and workplaces of his family. They were directed at people who were trying to take MilesGuo's money. These are not activities of a political movement. These are activities directed by a fraudster who wants to keep his money for himself. And how does this political agenda point that the defense is putting forth to you, how does that explain Crane? Crane was simply a way to bring in G Clubs and Farms money and to move it offshore. It had nothing to do with politics or political activism. But as with so many different things in this case, Guo wants it both ways now. When it's helpful to MilesGuo to claim that the NFSC and the whistleblower movement are entirely separate from the G series. That's what he does. When it's helpful for him to collapse them, as he's argued here, that's what he does. He's an opportunist. He's a fraudster. And what about Haytham Khalid's recordings? The defense barely mentioned them. Either with Mr. Khalid or in the nearly 4 hours of summation that you heard yesterday and today. But you listened to those. Mr. Khalid explained them to you. Are those recordings of the defendant talking about his political activities? No. In those recordings, he is demanding the movement of investor money. He is controlling his criminal fraud enterprise. And Mr. Kumraju, as I mentioned, briefly acknowledged the recordings today because he had to. It would be far too obvious if he didn't mention them at all. But what did he say? He said, the recordings are actually a defense for MilesGuo. They show he didn't control G Clubs because he told people to do something and it didn't happen immediately. That's proof that MilesGuo is somehow innocent. You know that that's not true. But even taking a step back, ask yourself one fundamental question. If he didn't control G Clubs, why was he on so many calls about G Clubs money? If he's just a spokesperson, what is his role in talking about the tens of millions? The hundreds of millions of dollars of G Club funds that are locked up at Crane? It does not make sense. There is one reason, and one reason alone, that he was on those calls, because he is in control. And the argument that the transfer is not happening immediately is proof somehow that Guo didn't control G Clubs. You know that's inaccurate too. Because the transfers did happen. It took a couple of days. They had to get around some legal red tape. But what MilesGuo wanted, MilesGuo got. Let's briefly listen to a couple of those recordings. This is 417. We went over this yesterday with AUSA Finkel. But again, bring to this the context that you have from all of the evidence in this case. April 28, 2021. It's a meeting among Guo, Yvette Wang, William J.E., Haitham Khaled, and Alex H., the G Clubs' financial controller. The defendant, MilesGuo, is instructing Yvette and William to order Harun He, the UBO of G Clubs, to send $100 million worth of G Clubs money and farm loan money abroad. You heard him in this call demand that the money be moved quickly. And when he got pushback. When Yvette and William said to him, "We have to paper this." What would a normal company do? We need to do what a normal company would do so the transfer goes through. You heard how MilesGuo, the boss of this criminal fraud enterprise, responded. Regardless of whose name was on bank accounts or corporate documents, you know that MilesGuo controlled G Clubs. And he controlled the money.
Audio played.
Ms. Murray said, "That doesn't sound like a spokesperson to me. That's the boss of a criminal enterprise. And he's still at it a week later. They are still trying to figure out the transactions. They are still trying to figure out what agreements they need to paper these transfers." On May 6, 2021. Khaled recorded more calls with MilesGuo, where Guo again directed Khaled to send the G Clubs and the farm loan money that was in Crane's account to William J.E.'s foundation, to Hamilton Capital. In one of those calls, Guo told Khaled he must send the money wherever he's ordered to. And when Khaled explained that the transfers are not covered by Crane's escrow agreement with G Clubs, Guo demanded to get G Club's lawyer on the phone. And he called bullshit.
Audio played.
Ms. Murray said, "Pause that." Says no, this is Guo. No, you need, if they said the investor money. He essentially says they give the order, you send the money to go anywhere. You must send it anywhere. You can see Khaled says to him, "Correct, but I can only send it. I only have an escrow agreement with one company." And Guo says, "No, if they want you to send it to a third party, you have to send it to a third party. The foundation. William J.E.'s company." Guo says, "They make the order to give you, you have to send it anywhere. You must send it anywhere." And again, Khaled asks him, "Which foundation?" "I'm confused." Guo confirms. William's foundation, the fund. And when Khaled says, "No, I only have an escrow agreement with G Club. I can only send the money to G Club," William jumps in. He says, "Well, you take instructions from G Club, right? You have an escrow agreement." And then Guo says, "What?" Khaled explains. The lawyer said I can't do it." Guo says, "Which lawyer said that?" "Who?" And when Khaled explains that it's Ana Izquierdo, the in-house G Club's lawyer, Guo demands that they call Ana. He says, "Call Ana now. See if we can play this one."
Audio played.
Ms. Murray said, the phone rings. Ana doesn't answer. And Guo yells at Gladys Chow. You've heard about Gladys Chow. She was one of his assistants. It's translated here because it's Mandarin on the recording. He says, "Find lawyer Anna's phone number for me." Again, not a spokesperson. This is the boss. And then he calls bullshit.
Audio played.
Ms. Murray said, "By the way, when you go back and deliberate, take a look at the transcripts for these calls and meetings. The Khaled recordings. It's the 400 series. You will notice that there is no discussion of political activism. There's no discussion of G Club's member benefits. These are calls about money. About hundreds of millions of dollars of money, about moving it offshore. About getting it into different bank accounts. They are not about the members. They are not about the whistleblower movement. They are about the only thing that MilesGuo cares about, money. And you should also take a look at how Guo refers to the money in those calls. Not as membership fees. Not as money from fellow freedom fighters or comrades in arms. No. As investor money. And keep in mind, these are calls that MilesGuo never thought anyone would hear. These aren't his broadcasts. He's not wearing a Brioni suit. He's not drinking tea in his Sherry Netherland penthouse. He's not riding around on his yacht talking about get rich quick, believe in me. I'll personally guarantee everything for you. These are the true MilesGuo. The boss of a criminal fraud enterprise. One other point that Mr. Kumraju raised today was about the government's witnesses, in particular. The insider witnesses. The people who were intimately involved with the businesses that MilesGuo used to raise money, Haitham Khaled, Limari Reyes, Jesse Brown, Yali. These insiders were pawns. They were used by MilesGuo. And like his victims, they believed him. They believed in him. When he told them to do something, they thought they were doing it in furtherance of legitimate businesses. They thought they were doing it for valid purposes. And those insiders, like the victims, they got nothing. MilesGuo got everything. He fooled many of his employees. He fooled many of his victims. Don't let him fool you. Ladies and gentlemen, the defense wants you to ignore the evidence in this case. They want you to brush aside the defendant's broadcasts and statements where he promotes all of the schemes of his criminal enterprise. Where he promotes GTV, the Himalaya Farm Alliance, the Farm Loans Program, G Clubs, the Himalaya Exchange. They want you to ignore these simple facts which the government has proven beyond a reasonable doubt. The defendant lied to people. He offered them stock and other things in return for their investments. And he assured them that both their investments would make them money and also that he would personally guarantee them against any losses. They want you to ignore that the defendant continued to personally guarantee them against losses. Even after he filed for bankruptcy in February of 2022. They want you to ignore the victims you saw and heard during this trial, victims who, one after another, said they had followed MilesGuo. They believed everything he said. But eventually, they woke up. Eventually, they realized, when they had trouble getting their money back or when he blacklisted them and called them CCP spies. They realized that he had lied to them. What Mr. Kumraju is asking you to do is to pick out one dot at a time. A single piece of evidence from each scene in the picture of this trial. Some from Rule of Law, a few from GTV. A couple more from the Farm Loans and G Clubs and the Himalaya Exchange. He's telling you to focus on each dot in isolation. And then he says that's not a picture at all. But you can't see the picture from inside the frame. So what the government is asking you to do is not to trust us, but to trust yourselves, to consider all of the evidence that you have seen and heard during this trial. To evaluate all of the dots together. And when you do that, you can see the picture clearly. It's a picture of the criminal fraud enterprise that MilesGuo built, that he controlled. That he used to tell lies and steal more than $1 billion from his victims. And when that picture is complete, there is one unmistakable conclusion: on all of the charges against MilesGuo, he is guilty.
The court said, "Members of the jury, I will now provide you with my final instructions before you deliberate. Please turn to page 68. Please turn to page 6843. Jury's duty to deliberate. Before you retire to deliberate, there are a few more areas I need to instruct you on. Your job is to decide whether the evidence establishes the guilt of the defendant with respect to the crimes charged in the indictment beyond a reasonable doubt. Deliberations must take place in the jury room with all jurors present. If any juror leaves the room, Say for a bathroom break, all deliberations must stop and may resume only when every juror is present. In order to return a verdict, each juror must agree to such verdict. You have the duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if it can be done without giving up individual judgment. As jurors, each one of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. No juror should give up any honestly held conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. During the course of your deliberations, you as individuals should not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. For those of you who took notes during the trial, remember that any notes that you took are to be used only to refresh your own memory during deliberations. They may not be used as authority to persuade your fellow jurors as to what a witness did or did not say. Your notes are not superior to your or your fellow jurors' independent recollection. Those of you who did not take notes should not be influenced by the fact that another juror has taken notes. Rather, you should rely on your own independent recollection of the evidence. If there is a question as to what the testimony was or what my instructions to you were, you should ask to have that portion of the testimony or the instructions read back to you. Your notes and the notes of your fellow jurors are not a substitute for the official record or for the governing principles of law that I set forth. The court's transcript prevails over a juror's notes. You will have in the jury room a laptop with the exhibits introduced into evidence, should you wish to consult them. This laptop can connect to the large monitor in the jury room. If during the course of your deliberations, your recollection of any part of the testimony should fail, or if you should find yourself in doubt concerning my instructions to you on the law, you have the option to return to the courtroom for the purpose of having such testimony or instructions read back to you. If you want any further explanation of the law as I explained it to you, you may also request that from the court. If there is any doubt or question about the meaning of any part of this charge, you should send me a note asking for clarification or for a further explanation. Your requests for exhibits or testimony, in fact, any communications with the court, should be made to me in writing, signed by your foreperson, and given to one of the court security officers. Your foreperson, juror number 1, should write out your request and give it to the court security officer, who will deliver the note to me. Please write the note on one of the jury note sheets of paper and place it in an envelope for the court security officer. As soon as the attorneys, the defendant, and court staff are assembled in the courtroom, you will be called back to the courtroom and I will promptly respond to your request. During any readback of testimony, keep in mind how the witness's demeanor appeared to you as you observed the witness testify. In any event, do not tell me or anyone else how the jury stands on the issue of whether or not the defendant is guilty until after a unanimous verdict is reached. In order to reach a verdict, all 12 members of the jury must agree. Whenever all your members are in agreement on a verdict, you must report your verdict to the court. When you have reached a verdict, simply tell the court security officer you have reached a verdict, but not what the verdict is, and you will be promptly called back into the courtroom to announce your verdict. We have prepared a verdict form for you to use in recording your decisions. After you have reached a verdict, the foreperson should fill in the verdict sheet, sign and date it, then give a separate note to the court security officer outside your door, stating that you have reached a verdict. Do not specify what the verdict is in your note, and do not include the verdict sheet with the note. Instead, the foreperson should retain the verdict sheet and hand it to me in open court when you are called in. Because the trial jury is about to retire to deliberate, I now charge and I emphasize that there must be no further communication or contact between the trial jury and the alternate jurors. The alternates are not to discuss this case with anyone, including yourselves, nor are you to read, watch, or listen to anything from any source concerning anything touching on the subject matter of the case, nor are you to permit anyone to discuss the case with you or in your presence, nor are you to form any opinion as to the factual issues in this case, nor are you to form or express any opinion as to the guilt or innocence of the defendant, unless and until such time as you may be requested to participate in the trial jury's deliberations. The alternates may leave the courthouse. However, you still may be called upon to replace a juror. so you must remain reachable by telephone, text, and email. And you must be able to return to the courthouse within 1 hour of being contacted by my staff. During your deliberations, lunch will be provided. You should not leave the jury room during deliberations unless you are instructed to do so. Are there any smokers on this jury? If you are a smoker, as I will not be in the jury room with you, should you desire a smoking break, you must make the request to your jury foreperson. Should the foreperson declare a break, the court security officer must be notified. During this break, all deliberations must cease. As smoking is not permitted inside the building, the smokers will be escorted by the court security officer outside the building to smoke. During this recess, the smokers outside the building cannot discuss this case, and the non-smokers in the jury deliberation room cannot discuss this case. You may not resume your deliberations until all of you are back in the jury room. Do you all understand? Counsel, do you wish to approach?
Ms. Murray said, "There's nothing from the government, Your Honor."
Mr. Kamaraju said, "Nothing from defense, Your Honor."
The court said, "Now, I'm about to submit this case to you for your final determination. As I previously stated, the law and your oath require that you render a fair and impartial verdict without fear, favor, or sympathy. Now, take this case and in the fulfillment of your oath and in accordance with the instructions of the court, render a true and impartial verdict. Please escort the jurors out. Oh, one moment. I want to swear the court security officer."
Marshal sworn.
The court said, "All righty. The jurors may be escorted into the jury room."
At 12:04 p.m., the jury retired to deliberate.
The court said, "Please be seated. Given that there was no request to approach, may I assume that there are no exceptions to the charge?"
Mr. Kamaraju said, "Nothing from the defense, Your Honor."
The court said, "I didn't hear you."
Mr. Kamaraju said, "Sorry. Nothing from the defense, Your Honor."
Ms. Murray said, "Nothing from the government."
The court said, "So have you prepared the laptop with the evidence?"
Mr. Finkel said, "Yes, Your Honor. It's prepared. We could give it to your law clerk."
The court said, "All right."
Mr. Finkel said, "Just for the record, defense counsel has had an opportunity to review it. And I understand that defense counsel has consented to what's on the laptop, as have we."
The court said, "That is accurate?"
Mr. Kamaraju said, "Yes."
The court said, "You don't have to remain in the courtroom. Just make sure that my clerks have your contact information, which I think they already have. Is there anything further?"
Mr. Kamaraju said, "Not from the defense, Your Honor."
Ms. Murray said, "Not from the government."
The court said, "All righty. We will be in touch."
Recess pending verdict.
The court said, "Please be seated. It's 4:59. I have not heard anything from the jury. I don't have any notes. Is there anything before I dismiss them for the day?"
Ms. Shrofa said, "Not from the defense, Your Honor."
Ms. Murray said, "Not from the government." Thank you.
The court said, "All right. If you'll have them brought in, please."
Jury present.
The court said, "I understand that the foreperson has a note for me?" Foreperson, "Yeah, we're just requesting some documents." The court said, "If you'll please hand that up. And please be seated." So this is jury note number 1. States we, the jury, request physical copies of transcripts, restatement of limiting instruction. It's signed by the foreperson and it bears today's date. I'm going to make this court exhibit number 1. So we will discuss your note and address it tomorrow morning. So your work for today has finished. You'll come back tomorrow morning and you'll start at least by 9:30. But of course, if you are all gathered together before 9:30, you can start at that time. So the old rule applies. You're not allowed to discuss the case amongst yourselves. Don't permit anyone to discuss the case in your presence. Don't read, watch or listen to anything from any source that touches upon the subject matter of this trial. Once everyone is all gathered together tomorrow, you can recommence your deliberations. Have a good evening.
Jury not present.
The court said, "Please be seated." So with respect to the first request, physical copies of transcripts, I would like to ask if there are particular witnesses and whether or not they're looking for the direct. Or the direct and the cross or just the cross?
Mr. Finkel said, "It's also possible, Your Honor." By transcripts, they mean transcripts of some of the recordings or the videos that are in evidence.
The court said, "Oh, that's true. I didn't think of that. Okay, so yes, maybe it is merely, but don't they have those?"
Mr. Finkel said, "They have them electronically. They might want them physically to read, a hard copy."
The court said, "Okay, so then if you would prepare those hard copies, and I think it would be handy to prepare 12 of each."
Mr. Finkel said, "We could do that."
The court said, "Is it too voluminous to do that?"
Mr. Finkel said, "We could do that. One of them is 200 pages long."
The court said, "Oh, that's very voluminous."
Mr. Finkel said, "We'll prepare if it's okay with the court, we'll prepare several copies. We'll figure it out. We'll give the defense an opportunity to review them, obviously, in the morning, if that's okay with Your Honor."
The court said, "Yes. I don't mean that you should stay up all night Xeroxing."
Mr. Finkel said, "We're used to it at this point. Why should tonight be different from any other night?"
The court said, "So then they ask for a restatement of limiting instruction. I don't know what they mean. I'm certainly hoping it's not a restatement of the jury charge. But does anybody have any ideas?"
Mr. Kamraju said, "I think it might make sense to ask them in the morning whether they are talking about, like Your Honor, it could be what Mr. Finkel said. It could be particular witnesses. Because the way I hear it is limiting instruction. And there have been a few over the course of the trial with respect to hearsay or something like that. So I think it might make sense to ask them to clarify because, I mean, I've never had a trial where we sent the entirety of the transcript back to them. That would seem odd. So I think it might make sense to ask them in the morning what they are talking about. And then assess whether they just want you to read or reissue a limiting instruction with respect to a particular witness's testimony or a particular item of evidence that's come in."
The court said, "So what I'd like the parties to do is to identify the limiting instructions, so that we have those handy for tomorrow morning. Is there anything else?"
Ms. Shrofa said, "Your Honor, I apologize. But it's unclear from the note if they mean transcripts of the trial or transcripts of the videos or transcripts of the recordings. Perhaps it would be prudent of us to ask the jury to simply say, 'Could you please be more specific about which transcripts the court should send back to you?' Because it could be we just send them the wrong transcript or we guess wrong. I think that might open up a Pandora's box down the road."
The court said, "Oh, I'm not suggesting that we simply hand them the transcript, the translations essentially. I'm not suggesting that we just give it over to them. I would ask them tomorrow morning. I just think that we should be prepared to do so. Now, with respect to the transcript of the testimony, that is not something that I think we should guess at this point. Hopefully it is merely the translation."
Mr. Kamraju said, "That makes sense to me, Your Honor. And in terms of identifying the limiting instructions, I guess we can identify the places in the transcripts where the court has given limiting instructions. And then based on what the jury responds for the inquiry, we can decide which limiting instructions need to be restated or said to them again or just provided with the transcript, if they are asking for them."
Mr. Finkel said, for the record, "The government agrees with defense counsel in that we should clarify with the jury precisely which transcripts or translations they want, and also what they mean by limiting instruction. I think we're all on the same page."
The court said, "I've never received a request for a limiting instruction."
Mr. Finkel said, "As you noted, this is an unprecedented trial."
Mr. Kamraju said, "Well, and I think, Your Honor, I've never had that either. That's pretty confusing. Especially because there are different limiting instructions that apply to different testimony and exhibits, right? So I don't think, for all the same reasons, I don't think we can guess at which limiting instruction it is that they want to be restated. So we can identify the ones that exist and then figure it out once they clarify for us."
The court said, "It's possible that they read the section about limiting instructions and may not know what we were referring to."
Mr. Kamraju said, "That's true also."
The court said, I certainly hope it's not the whole charge.
Mr. Finkel said, Your Honor, just one question. Is it separate? We haven't seen the note. Is the note separated where it says this is Request 1 transcript, and Request 2 is the limiting instruction? Or are they together?
The court said, so on the first line it says, we, the jury, request physical copies of transcripts, period. On the second line it says, restatement of limiting instruction. I will provide a copy of this to you, but they distinguish between the two things.
Mr. Finkel said, okay.
Mr. Kamraju said, even if they do mean, Your Honor, the entire charge. I think probably it would make sense even then to ask them if they can be more specific as to what they want.
The court said, I assure you I will do that.
Mr. Kamraju said, I assumed as much.
Mr. Finkel said, sorry, Your Honor, every judge has a different practice. Do they have a copy of the charge?
Court said, oh yes.
Mr. Finkel said, okay. So that's helpful to understand as we consider what they need. Okay.
The court said, I heard that in Judge Hellerstein's trial there was a request for a summary, a one-page summary of the RICO charge. So that's something perhaps to think about.
Mr. Finkel said, did Judge Hellerstein provide that?
The court said, apparently.
Mr. Finkel said, okay.
The court said, and I will be taking a look at it.
Mr. Finkel said, we will too.
The court said, okay. So you do not have to return to the courtroom until 9:30. I don't expect that they're going to be gathered together. Oh, wait a minute. Now I'm being told that they are usually all here by 9 a.m. So then you should be prepared to get started at 9 a.m., which would be better for all of us.
Mr. Kamraju said, is it Your Honor's intention to send a note back to them asking for clarification or to bring them out and ask?
The court said, going to bring them out and ask.
Mr. Kamraju said, okay.
The court said, now their answer, however, I'm going to send them back to write down their answer. I'm not going to take their answer in open court.
Mr. Kamraju said, right. No, the answer would come via note.
The court said yes.
Mr. Kamraju said, okay. That makes sense, Your Honor. Thank you.
The court said, all righty. Thank you and good evening. My brilliant law clerk suggested that perhaps they might be referring to the transcripts that they had in the jury box when they were listening to testimony, so something to think about.
Mr. Finkel said, Your Honor, if I may, does your staff still have those? Okay. So with respect to the binders, we wouldn't have to prepare new ones. Okay. Thank you. Thank you for keeping those.
The court said, all righty. Have a good evening.
Mr. Finkel said, thank you, Your Honor.
Mr. Kamraju said, thank you.
Adjourned to July 12, 2024, at 9:00 a.m.